So we've talked about how to carry out an effective investigation, and all the way through an investigation and post-investigation there is a lot of decision making, and it's very important to, I guess, do that in the right way, or certainly a way that is defensible once you've made those decisions. So I'm really interested in your thoughts around that and how best to approach it.
Neil, do you want to go first?
I can do. I think recording your decisions, as you say, during an investigation helps you so much later. Explain, if you need to, why you took certain forks in the road. We decided to look at this person's emails because they were relevant to this issue. And if then later something crops up and you haven't looked at someone's emails, you've got a record of your contemporaneous views on why not. So it just supports the judgment calls you make if you're recording your decisions in an investigation log, whatever is appropriate for your organisation and what you're comfortable using. But documenting your decisions as you go through really helps later lead to that point where you're ready to report overall on your fact finding.
Just lead on with Neil there. I think it's crucial when you are recording your decisions and recording decisions from the information you have at the time, because it's limited. When the hindsight police come in at the end of something, it's dead easy to criticise, but you might not have that information when you made that decision. So you're making decisions what you're going to do, and perhaps make decisions that you're not going to do something at that moment in time. I see quite often where organisations fret or discuss understandably about, well, should we suspend somebody? Should we not suspend somebody? And I think there you're making decisions on people's livelihoods, and you're making on people how they feel. You know, suspension's supposed to be a non-neutral act, but does the individual feel like that? So again, you're writing and documenting why you're taking steps to suspend somebody, or likewise, why you're not. Especially when some cases are getting media attention, where the organisation's under some pressure, well, why is such and such not being suspended? So I think it's crucial to be writing your decisions at that time in some kind of log, some kind of case management system. So if somebody comes back later on, you'd say, well, yes, this is the information I had at the time, and that's why I made that decision.
Ultimately, it's all about fact-finding, and I go back to something that Neil was referencing earlier on. There is a tendency sometimes for organisations to want the investigator to be also the decision maker. And
I was just going to ask you about this, that was a great segue.
and bodies such as ACAS are very particular about the separation of the decision maker from the investigator. The decision maker has a different role from the investigator. The investigator finds and determines the facts. It's the decision maker who decides on that person's fate, if you want, for a better expression. And that's about ensuring that the investigation is fair, transparent and biased, and that the investigator, you haven't got one eye further down the line for, well, what's the sanction going to be? Yeah, you might take it into account in the scope of the investigation, but you shouldn't really have that at the forefront of your mind.
And this comes up quite a lot within cases that we're working on, doesn't it? Because we often, I think, you know, there's the question of who makes that decision. Is that is it internally? Is it the external independent person? So can you talk a little bit about that, please?
Typically what we'll be asked to do is, and we use the words that because all organisations use different terminology. Proven, not proven, found, not found, substantiated, unsubstantiated. But typically we will make a recommendation that the case is proven on the balance of probabilities. That can be a sliding scale depending on how severe the matter is that you're looking at. That on the balance of probabilities, either this has happened and here's the information that supports that, or we don't think this has happened and here's the information that supports that finding. But what we don't then do is say, and then we think that person should appear on a discipline hearing, because that's the decision makers.
The internal decision makers.
As an investigator, you haven't got sight on that person's antecedent history, what they've been involved in previously. There might be 25 years of unblemished history, which shouldn't impact your thinking as an investigator looking for the facts, but may well influence as to whether that person suffers any kind of consequence thereafter.
Neil, what do you think on that?
I think, yes, it comes back to what we've talked about, that the investigation is a fact-finding process, so the fact-finders should do the fact-finding and report on the evidence that they see and assess. and they should come to an assessment. It's not just spewing out the facts. They can assess it, but they might not be the people qualified or equipped to make decisions. That might be outside of their function, and having that separation is important for the show the investigative process is independent. I mean, some of the hazards we see is that people maybe write up their decisions, their fact finding, they're the investigators, and they are tempted to provide opinions about those facts which they're not qualified to do for whatever reason. Someone, for example, making a judgment about the effectiveness of the overall compliance programme when they've only investigated one tiny part of it. And those are tendencies that report writers and investigations can sometimes have. So, bad investigation reporting also is where people extend beyond their competency, extend beyond the scope of what they investigated. If you have non-lawyers, I'm sorry I'm being biased here, if you have non-lawyers giving a view on the legal liability risk, that's probably not helpful as an organisation for your investigation report. If you have non-lawyers saying, we've investigated these facts, we think this should be sent to the legal department for a view, perfect. If the legal department haven't already been involved in overseeing the facts, because they may have been, because the legal risks involved. So I think it's just about thinking what your investigator is competent and capable of reporting on and what they're not.
It's quite a skill by the sound of things, and to make sure that that report does sort of follow that approach. And we've talked about it before, but coming back to that whole, it's important that you choose your investigators correctly, and that they're trained so that they can perform that function effectively. Sounds really important. Thanks very much for your thoughts on that.